Deadly claims in trust and estate law. That's the subject of today's ACTEC Trust and Estate Talk.
Welcome to ACTEC Trust and Estate Talk from the American College of Trust and Estate Counsel, a professional society of peer-elected trust and estate lawyers in the United States and around the globe. This series offers professionals best practice advice, insights, and commentary on subjects that affect our profession and clients. And now, our ACTEC Fellow host with today's topic.
This is Stacy Singer, ACTEC Fellow from Chicago. As estate and trust litigation intensifies around the country, a wave of novel claims has been evolving. Most trust and estate professionals need to be educated about these claims and may not be aware of them at all. ACTEC Fellow Steve Mignona of New Jersey shares significant developments and identifies pitfalls for T&E professionals across the United States. Welcome, Steve.
Well, thank you very much, Stacy. Happy to talk about this. This is a project that several of us, Bob Goldman from Florida and Terry Franklin from California, have worked on for probably about 15 years. We decided over those years to try to track unique claims involving estates and trusts. We found that over that time, I don't think this will surprise anyone, society's become more litigious, and there has been more litigation involving estates and trusts and fiduciaries and the elderly. There's also been more splintering of families and more disharmony among families, and likewise less trust in institutions. So a lot of that is a matter of perception, but nevertheless, Bob, Terry, and I felt that that was occurring, and that led to what we believed were very creative or novel claims involving estates and trusts. So reaching back 15 years or so, we started to track them and see how different states were handling them. And this is a version of the ones that we think are the current interesting, unique, and novel claims. We always joke that this area reminds us of that phrase that a lawyer is a learned person who rescues your estate from your enemies and keeps it for himself. Litigators can be a little cynical that way. But that's the nature and background of the project, and I always want to acknowledge the work Terry Franklin and Bob Goldman have done with me over the years in trying to, as I say, monitor these claims because they are ever evolving. And if you survey the states, you'll see that states have handled these differently. And if you check in with one state in 1 year, you'll find that 2 or 3 years later, that state may handle them differently. So let me go through what we would call the 7 main claims. The first one would be pre-death will contests. Now, I've been practicing for a few decades, and when I started practicing law, a will contest was fairly straightforward and simple. Now, estate litigation is much more complicated. There can be pre-death transfers or changes in beneficiary designations. Those are much more common than just a will contest. And in fact, because of that, this issue of pre-death will contests has become more common. The issue is that traditional rule is that a court will not want to hear a will contest until the person has passed on, and therefore the final will is determined. Against that, though, is the problem that you might have litigation involving asset transfers or gifts or beneficiary designations, and those are all done within the framework in which the will itself was changed. So more and more courts are saying, well, if we're going to have a trial regarding these other issues, we might as well go ahead and address pre-death will contests. So pre-death will contests are now evident in many states, and in fact, some states have statutes addressing the viability of these claims specifically. Number 2, we would list tortious interference with inheritance. I think the best way to describe this is to give 2 examples. If my current will benefits Jane, and I want to change my will to benefit John, Jane may find out about that. And Jane may decide, okay, I don't want Steve McDonough to change his will because I want to get his assets when he passes away. Everybody knows Steve's worth billions of dollars. So Jane may preclude me from changing my will, especially if I have any type of debilitation. And therefore, there is no will to challenge for the person who would have become my beneficiary. That's one example, and that's why this tort would be more viable, because there's no will to challenge, and I was prevented from fulfilling my intent and wishes. The second is what I mentioned before, that a lot of times assets are transferred outside of the will, and therefore a person may be a beneficiary of the will, but decide that assets that should have passed under the will don't. and they want to bring this tort to say these assets should be brought back into the estate. So that's number 2, tortious interference with inheritance. We'd say that number 3 are various trust-related claims. Trust protectors are, I think, a relatively new concept, and there is more and more case law about claims involving trust protectors, as well as claims involving the amendment, interpretation, and reformation of trusts. So we categorize those collectively, but as you can see, there are a number of sub-claims there involving trusts, and we think that will continue all the more. Number 4, various divorce-related claims. More and more palimony claims are now being brought against estates, and various states have enacted statutes to deal with palimony claims. There's also the intriguing area of post-death divorce. While the traditional rule was that a person's passing would terminate a divorce proceeding, that's started to change because of equitable considerations and whether it's fair to have the deceased person's assets pass in such a way as though the divorce had never occurred. So we're seeing a lot of that as well. And there's an awful lot going on right now with trusts and divorce. I've had experience with this, and I know others have as well, where judges have to deal with whether a trust would get pulled into a divorce and the assets of the trust would become part of the divorce. And one of the recent ones I had to deal with, and I think this happens often, the issue arises in family court, in the divorce court, and the judge may not be very conversant in trusts, and it makes it all the more complicated. Number 5 would be guardianship-related claims. More and more multi-jurisdictional disputes involving guardianships, wards and incapacitated persons being moved around, whether by convenience or for medical reasons or for nefarious reasons. And similarly, whether the doctrine of substituted judgment is effective, where the person's assets are defined at their death by some type of substituted judgment that occurs in the framework of a guardianship. Number 6, we'd say are writings intended as wills, and this is a whole separate lecture. But the bottom line is that many states, including my state of New Jersey, have statutes that say non-traditional wills, which don't meet the usual standards but can be shown by clear and convincing evidence to be testamentary, can still be valid. These statutes define the documents, quote, documents very broadly, and also in most instances do not even require a signature. The idea is for our area of the law to keep up with technology. So, for example, there are cases that we've tracked that have iPads and iPhones and DVDs all admitted to probate. I myself have had cases where Post-it notes have been admitted to probate. Heck, in one of the cases here in New Jersey, a codicil to a will written in the person's blood was admitted to probate. So this writings intended as wills seems to be on the upswing, and I think will become more common, but there's a real tension between the traditional requirements for a will versus the idea of trying to fulfill a testator's intent, even if the document is not in traditional fashion. And then finally, number 7 would be insane delusion and duress, which are not really undue influence, but often confused with undue influence. And the thinking is that insane delusions and duress are more common, but still often forgotten, especially as the population ages and becomes more susceptible to those types of delusions or duress. Well, those are really the main ones, the 7 ones. As you can see, it's hard to really pinpoint the number because it's ever changing, but the fun part is that Bob, Terry, and I have gotten together every few years to talk about this, and as we chart these claims, they have changed. Some have been dropped, some have been added, but it's always fun to see how the various states handle them and how judges struggle with them, and we think it's important that we as practitioners are aware of them. So I appreciate your time and attention.
Thank you, Steve, for that great presentation on the 7 deadly claims, and thank you everyone for listening.
Thank you for listening to this episode of ACTEC Trust and Estate Talk, the podcast series about wealth planning matters from the American College of Trust and Estate Counsel. To find an ACTEC lawyer near you, visit actec.org. Please subscribe to this series and leave us a rating or a review.